Good afternoon, ladies and gentlemen. Fresh air is good, but not too much of it, correct? Yes. Good afternoon. Welcome back. You are the hardcore of the Fidel who have stayed today for our third and final session after lunch. So my thanks in advance to you for that. But we will vindicate your confidence, because we'll have an absolutely splendid final panel where we'll be looking at the rule of law, justice, the reform of justice in the Western Balkans in the perspective of EU enlargement, and asking ourselves, is meaningful change taking place? If so, why and how? If not, why not, and how to fix it. Let me introduce myself. My name is Jamie Shea, ex-NATO, but the last few years I've been a senior fellow here for Peace and at Friends of Europe for Peace, Security, Defence. You heard from another senior fellow, Val Zanelli, in the previous panel. You're probably asking, what's the difference between her and me? Well, senior in her title means she knows something about the subject, and senior in my title means I'm very old. But even if I'm not a lawyer myself, I'm married to a barrister, my daughter's a barrister, and my son is a barrister. So hopefully some of that has rubbed off on me, at least in terms of being able to set the scene and ask at least some of the right questions. In the UK a few years ago, I don't know if you had it here in Belgium, there was a famous advertisement for Heineken beer. And the Heineken beer said, "Get the head right and the rest will follow." And to my mind, if I think of the rule of law, it's the same, right? You know, if you don't get that right, what else can possibly follow? Because the rule of law is the basis of predictability, of contracts, of assurance, of people's confidence in the whole democratic system, which sort of drives everything else. Human rights, protection of minorities, the political process, the function of the democratic institutions, the citizens' right to petition government for justice and reparation. We heard in the previous panel about investments, how critical a robust legal framework based on an independent judiciary is for businesses to have the confidence to invest, particularly for the long run. It undergirds international agreements as well. And needless to say, obviously, despite all of these great qualities, the countries of the region have to meet rule of law standards in any case as one of the key conditions for accession to the European Union. There simply is no way around it. But we also know, from our own experience, even in our Western countries, the rule of law is never a done deal. It's constantly a work in progress. If you're not moving forward, you can easily slide back. I mean, in the UK, coming from London yesterday, this week, we're not in the EU any longer, but still, we've got this incredible issue of unbelievable delays in legal cases coming to court. So much so that we're the country that founded common law. We're actually debating suspending juries to try to speed up the process. And we've had this week a police investigation into the Hillsborough football disaster, which took 39 years. 39 years, with the result that nearly all of those who could be prosecuted are dead or retired long ago. So I just say that to say that I think that as we focus inevitably on the Western Balkans, we also have to realise that it's always a difficult issue for us as well. Of course, we also in the rule of law have to have not just adequate number of judges. The institutions have to be well staffed and well equipped to be able to function. There's also public confidence in the process itself. Justice delayed is often justice denied, as I was saying a moment ago. The judges have to also be able to deal with increasingly complex issues like cybercrime, for example, or increasingly difficult financial instruments and so on, particularly in criminal or corruption cases as well. They need to keep up with the evolution, AI, for example, of technology too. And of course, it's great that you have laws which are adapted to the particular challenges of a particular country. Does it have an issue with terrorism? Does it have an issue with public procurement? Does it have an issue with corruption, for example? Does it have an issue with political interference in the judicial system? But those verdicts have to be implemented as well, and not just delivered if justice is to be done. Jeremy Bentham once said that the price of democracy is eternal vigilance, and I would guess that the rule of law also requires internal vigilance. And of course, not only is the European Union closely assessing the progress of the candidate countries in such a vital area, but on top of that, we've got a whole host of NGOs, you're familiar with them, think tanks and research institutes that are also scrutinising this picture as well. So there's a high degree of attention and transparency focused on it. The last EU enlargement package last month shows inevitably, like in other areas that we've been discussing at this meeting, a mixed picture of certain countries obviously doing well and making progress, other countries still suffering from particular issues, for example, when it comes to judges, training judges, investments, institutions, dealing with corruption, and the like. The question, of course, is do all of the countries of the region need a kind of common legal framework? We discussed a common currency, the euro, in the last session. Law is often a national thing, right? But to how much does it have to be aligned across borders to function well? I think that would be an interesting question for our panel today. Clearly, there are some questions that we want to put to our panelists. First of all, are the instruments that the EU is deploying in the region doing the job? In Brussels, we always read about announcements, press releases and new initiatives. There's always less on are they being implemented and are they being followed up? Are they working? So I think that's going to be a question. Are the instruments the right ones and are they working? We know that the region has a difficult legacy with the rule of law, but is that legacy being overcome? If there are obstacles, what are they and how easily can they be removed? Are the candidate countries working together in this area, as we heard previously that they were working more closely together in the economic investment area as well? And ultimately, from previous experience, what are the best practices and the best ways to guarantee judicial independence, impartiality, and integrity? And member states, are they leaving all of this to the Commission, or are the EU member states, particularly the countries in the region, we think of Croatia, Slovenia, that have been through the process already, helping the candidate countries as well? So those are simply some questions which I put up. Fortunately, I don't have to answer them. I couldn't in any case, but we do have four of the very best for that. First of all, Helene Barker, who is the Director General for Economic Cooperation at the Netherlands Ministry of Foreign Affairs in The Hague, who has kindly travelled down from The Hague this morning to be with us. I'm not going to give the biographies because they are in the programme, but I will ask Helen to intervene first. Then we have Judge Ingrid Delvaux. Always good to have a legal practitioner on the panel. She's the Secretary General of the European Judicial Training Network, so good issue which I mentioned about, are we training enough competent judges in the region? Then we've got Surgeon Mastro Mastrovovic. Have I pronounced it? Almost. No, it wasn't perfect, but was I at least 90% there? Who is from Serbia. He was very involved in a previous life in Serbia's accession negotiations, but now is the chairman of the European Policy Centre, which also represents a network of regional think tanks and EU policy research centres. And finally, we have a well-known character on the Brussels scene, Thomas Weitz, member of the European Parliament. Always, of course, good not just to have a legal person on the panel, but somebody who represents the European politics as well. He's in the European Parliament, but he takes a particular interest in the Western Balkans because he's chair of the European Parliament delegation dealing with Montenegro and a standing rapporteur for North Macedonia. And you deal with Bosnia and Albania and the whole region as well. So I think we've got, all of the right perspectives that we need. So I'll first of all then turn to you, Helen, to start us off. In particular, Netherlands, your own country, takes a fairly stringent view, I know, given the state of Dutch political opinion and public opinion on standards and merit and compliance, particularly with the rule of law. Maybe what your own country is doing also practically here, and what you would sort of expect to the sort of European mechanisms to be contributing in this area. So, microphone is there. You've got it already, yeah. So the floor is yours.
Thank you so much. And first of all, it's really a pleasure to be here this afternoon. So thank you for the invitation. I'll be happy to say a few things on the Dutch position when it comes to EU enlargement, but maybe just to pick up on something you said, Jamie, on how important rule of law issues remain also after accession to the Netherlands. This is also a very important issue. You'll see that we keep up this emphasis on rule of law also within the EU when it comes to the rule of law toolbox for member states, the rule of law dialogue that we have with the rule of law report, but also looking at financial instruments, the next multi-annual financial framework, to see if we can have the conditionality that is already in the present MFF also extended when it comes to financial instruments. So it's really consistent approach. It's never perfect, not upon accession, not after accession. Same goes for the Netherlands. We also still have improvements to make, but we're happy to have that kind of peer review and also, if need be, that kind of pressure in the EU. And sometimes it gets very difficult because there are also EU member states that do suffer from backsliding. And, do we have the right responses there? Is the rule of law toolbox sufficient? Yeah, those are questions that we also often address. Now, when it comes to enlargement, I would say it's been one of the most successful external policies that the EU has in terms of transformation. If you look at any country that in the path towards accession or after accession, there's always been convergence, more interaction. I think it's fair to say that we've been better off because of enlargement, and that really in the countries that did accede also there was a big transformation that happened there precisely because of accession. It's painful, it's difficult, it's cumbersome, it can last a long time as well. This reform agenda is not for the meek at heart. I think we've seen it also up close in the last rounds of accession, 2004. And that was still in a different climate when in my country also the accession of the 10 new member states was really also seen as the correction of a historical injustice, these countries taking their rightful place around the table. But in the process that led up to it, we could also see the importance of rule of law. I think the methodology has changed, has been adjusted in the years that followed. And also Croatia's accession in 2013, the last member state to join. And now you can say, yes, indeed, rule of law is very much the fundamentals, very much center stage when it comes to accession. Let me say also something at the outset about the geopolitical perspective or the geopolitical dimension of EU enlargement, because that's something that's very topical. It's often said to be maybe at odds with a merit-based approach. We don't see it that way at all. I think they go very well hand in hand. The Netherlands very much sees the geopolitical dimension, the geopolitical importance also of strengthening our bloc, our EU, also given the position in the world, the geopolitical context. So really that geopolitical prerogative or imperative is there, and it's always been there, and it's especially felt in these days. But it's not at odds for us with the merit-based approach. I think consecutive Dutch governments have placed a lot of attention to that merit-based approach. Sometimes the wordings change a little. This current, now caretaker capacity government has said we place the Copenhagen criteria center stage. Prior, we always talked about strict and fair, adding also engaged, so strict, fair, engaged, all three elements being very central. But yes, I think if you say we're strict, we're considered as strict, I think sometimes also the acceding countries themselves ask us also to keep up the bar, to keep up the standards, and not to make any shortcuts in the accession path when it comes to the criteria. So fair enough, we're strict. We also hope to be considered fair. So when countries have delivered, we can also move forward in the path. We've seen now that that's clearly happening. It's happening for Montenegro, it's happening for Albania, and we also would be ready to take steps with Moldova and Ukraine. We don't like bilateralization. It's not fair. It undermines the merit-based approach in our view. If you keep the accession process hostage because you have an issue with your neighbors, that should be resolved in a different manner. So I also say that also quite clearly. And then finally, the point of engaged. Yes, we do also like to assist countries when it comes to their performance, their reforms that they have to undertake. We focus specifically on the rule of law. We have programs for that. And in many of the acceding countries, I think there's been a long-standing bilateral cooperation also in addition to what the EU offers there. So when it comes to improving judicial reform, training, those kind of projects, often on a bilateral basis, sometimes also on a regional basis. So that's strict, fair and engaged. Something about public support, and then I'll end there. It's often said that there's been enlargement fatigue. I'm not necessarily sure that that's the case. I think we saw recently in a Eurobarometer that the Dutch respondents actually are in support of enlargement with 68%, which is it's not bad. It's above EU average. When you dig down a little further, Dutch respondents did say very important to keep up the values community, the rule of law, media freedom, democracy. So all these things that are enshrined to us in this merit-based approach are also very much part of the way that Dutch respondents view this enlargement. And therefore, the Dutch government, I think, also feels a little bit confirmed and reassured in the approach we are taking. I think leave it at
may I quickly, if you would allow me, just ask you a very quick follow-up question there. In the Netherlands, of course, and the Western Balkans are tied by history. The Netherlands was the home of the International Tribunal for the former Yugoslavia. It's now the home of the specialist chambers, dealing, of course, with Kosovo. Of course, the International Criminal Court. Does this kind of, legal track record, which your country is very famous for, make the rule of law a special sort of focus or an interest for you? Or am I completely off track here, and the two things in terms of enlargement are completely disconnected in the Dutch political psyche?
No, I mean, I think it's part of the mix, but I think the fact that The Hague is, we like to propagate it, of course, as the city of peace and justice.
Exactly.
With those international organizations as the host country, that's important. I think it also is important from a rule of law perspective, that we attach great importance to that kind of accountability. I mean, when it comes to the accountability for Russian war crimes and aggression, again, we are...
Yeah, exactly, with Eurojust.
And on the aggression tribunal, etc. So that really features into it. I think, the joint history is there, of course, in the bilateral relations as well. It's not necessarily only because these organizations are in The Hague that we feel there's another kind of connect as well to the countries of the Western Balkans.
Thank you. I'm saying that because we're nearly at the 30th anniversary of Dayton in a few days, so that reflection sort of came to me. Thank you very much. Ingrid, I'd like to turn to you now. I mentioned that you were very much focused on training and, of course, the whole question of what your organisation is doing in the region and how you see successes and challenges. But if I may also, you're from France, of course, a major European Union country. You have experience as a judge. You've worked in government. So could you say something, like I asked Helen about the specific Netherlands role, apart from, working at the European level, is there a particular French sort of investment in these kind of issues as well, which you may have obviously picked up in your time working in the French government and working as a judge in different regions of France? I always like a trick question to keep you on your toes.
Yes, indeed. It was not planned. So, but I have.
I know you can manage it.
Yes, but I have answers on that. First, I would like to start by thanking warmly Friends of Europe for the invitation. I'm really glad to be here, and I must say this is the first time that the EJTN, the European Judicial Training Network, is invited to contribute to these exchanges, and I think it is absolutely relevant. So, for those who don't know what EJTN is doing, actually we have a network bringing together the national judicial training institutions for judges, prosecutors, and court staff. And I would like to go back to the history so that you understand also the idea of the network, the aim of the network. We were founded 25 years ago after the Tampere Council, and you all remember that it was the creation of the European area of justice. And at that time, we knew the judicial training institutions, I was not there, but some of them, they knew that they had to be part of the creation of this area of justice, because the area of justice can work efficiently only if the European judges and prosecutors, they know each other, they can cooperate efficiently, and that only if they are properly trained on EU law. And we know EU law has developed considerably since then. So this was the aim at the very beginning, and we have now our unique role recognized by the Council of the EU and also by the European Commission, because we bring around the table all the EU member states' judicial training institutions, but also, indeed, we have welcomed in our community as observers the national judicial training institutions which are close to the EU. And among them, you have Western Balkans, you have Moldova, you have also Ukraine. So they are around the table with us. And we knew also that we had to cooperate with them. First, because of course we want to support the enlargement process. We are mostly funded by the European Union, so we want to comply with the priorities of the Union and to support where we can. So this is the first thing, of course. But there is also it was mentioned this morning that one of the reasons of the enlargement process would not be only peace, but competitiveness. And for competitiveness, you need an efficient justice system. So this is also what we want to support. And from the experience I have had also in the network, I can say that we think that cooperation with the Western Balkan countries is absolutely relevant also for us, for EU judges, prosecutors, and court staff, because, and here I will be a little bit blunt, although I'm French, it's not cultural.
Please do. We like that.
But we already have a single market with Western Balkans, with some countries in Western Balkans. And I'm sorry to say it, but it is the single market of crime. Because the criminals, they don't have borders. They don't have anymore. And it's been a long time that they don't. And we must face that reality. We must tackle that challenge all together. And when you were referring on my experience as a judge, I was working, so several years ago, I worked as an investigating judge in Nice, and I had many interesting files I will not disclose. It could take a long time, and I'm not allowed to do that. But I must say, I worked closely with the Albanian colleagues. I had very difficult files to deal with, and I must say it was difficult to work with non-EU countries. It was an additional work because you cannot use the EU instruments. We could not at that time. So it was an additional investment of time, and to be honest, maybe not all the judges will do that. But when I had this experience, I can say that there was a real will of cooperation with my colleagues in Albania. It was very, very successful, and I realized that indeed, when you share the same challenges and you work together, then you build trust. And this is what we need, to build trust. And we know that the relevant judicial training, the relevant step we must make if we want to support our colleagues and also make our cooperation efficient, is to have this peer learning approach, to bring around the table our counterparts and to discuss together, and also to have this not top-down but really horizontal work together. And we know that in the Western Balkans they face many challenges in terms of justice, and this comes also from the EU enlargement reports. You know that they have rapid reforms to face, to implement. There is a lack of institutional training capacities, unfortunately. There is also a lack of specialized curricula. There is a limited exposure to EU standards. So we know that the reforms, the rapid reforms, the many reforms they are facing can only work if the judiciary is prepared to apply them. Because it's easy to talk about rule of law, you know, and to be honest, even with my colleagues, sometimes we have discussions about rule of law. What does it mean, the rule of law? It's still in discussion, you know. When you say the rule of law, yes. So I try to give a very easy definition. The rule of law means that everywhere in Europe, the law must be applied equally to everybody in any circumstances. Yes, of course, but which law? What is the law to apply? When you see how complex the EU law has become, when you see all the discussions that has taken place in Poland, for example, on the application of law, because maybe the Constitutional Court was saying, no, you have to apply the law this way. The Court of Justice was saying, no, you don't have the right interpretation. And who at the end fought really to ensure the rule of law? The basic judges. Those who were able to say, no, we are going to apply EU law, we know what EU law is, and we tell you how we interpret and how you must interpret the law. So it's very important that the judges, they can have the knowledge on EU law, that they know exactly how to apply it, how to interpret it. But it's also important that they know how to apply it, and this is the know-how. And here, again, I can share a personal experience. It's always more interesting, I think. But I started as a judge, I was 26 years old. And it happened to me regularly, and I was very upset with that. When people were coming to the court, they were like, are you the judge? Yeah, I am, you know. I know you were expecting an old man, maybe someone with a lot of experience, but why? Because citizens, they do have expectations. They do have expectations on their judges, on their justice system. They want to have people, competent people. And of course, I was looking very young, so they were like, maybe she's not really aware of the law and what she has to apply to my case, so I can be worried. So this is very important to understand that at the end, the rule of law has a face. And this face is the judge, who will tell the people, look, this is the law to be applied, so I am, you can rely on your justice system. So this is very important to have this in mind, because indeed, at the end, the ultimate guarantors of the rule of law, they are the judges. And unfortunately, I don't know you, but I was not born independent. It's not like I'm 5 years old and I'm independent. Independent means you are competent enough to know which law you have to apply, how you have to apply, how you have to react to certain situations. And this comes with training, with proper training. When you are put in situations, and this is something we had in initial training in France, case-based situations. How do you react in this and this and these situations? So this is something that we must have in mind, that it has to accompany the judges, the judiciaries in all these countries. They need to have the proper training. And they need also to have the trainings on what matters today. Because we are in a digital environment. Do you respect a judge who is only working with paper, like me, and who is not able maybe to understand how the digital tools work, who has not the new tools? No, you might feel this judge is maybe outdated, I would like a new one, maybe I would like a younger one. So it's very important to accompany also our counterparts with all the training on digitalization. And this is also what we do at the EJTN. So we have an experience of working with the Western Balkans judicial training institutions. And what we see is that there is an enlargement fatigue, but there is also a training fatigue in the region. Because so many projects, so many people going there and telling them, okay, so now I will deliver your training on this bloop, this bloop, this bloop. So they go, they learn, yes, then they leave and they forget. So this is not the way we should work, and this is not the way we work. What we see is that when we bring them to the table, to our table with EU counterparts, first we meet motivation. And here I have an example to say I have a Serbian close to me. It's not because of that, but I want to congratulate you because in 2022, we organize, so every year we organize a Eurovision of the EU law. We call it the Themis competition. It means we have different teams, future judges and prosecutors competing against each other on an EU law topic. So we brought to the table the Serbian team. Guess what? They won. And we were very, very surprised. And we were even a little bit embarrassed because we had not planned to organize the final competition there. This was the rule. You won, so you must host the final competition for the year after. So it shows that the fact that you bring them to the table, then you encourage motivation. And there is a will, of course. But then we also work having in mind the specific challenges they face. And this is why we know there is also a need for a tailor-made, long-lasting, continuous training in the region, and it goes, of course, with involving them and having them on the table of the discussions. So,
can I ask you on that? I mean, when you have engaging the region, are there? You mentioned digitalisation. Are there other sort of quick wins? Because obviously the reform of the judiciary, I imagine, a very slow, bureaucratic affair. Training judges takes time. It's like medicine. It takes a long time to train as a competent lawyer and a judge. But are there sort of quick wins that you've identified? That, do you see that the governments are putting sufficient resources in? Do salaries need to be improved? To attract more people into that type of profession. Can they reorganise things, maybe so that the proceedings could take place faster at a lower level? These kind of things that accelerate the process that you can do quickly, so that, we were talking this morning when we were talking about economics, quick wins, what can we do in terms of, delivering things that show the population that things are happening, that justice is better, that it's faster, the citizen has greater access to justice, that, sort of create patience while you're dealing with the longer term reforms. In your travels of the region, do you see that, there are certain quick wins? And are there still some big obstacles, for example, like lack of resources, that you would like to change if you could?
Of course, the resources are an issue, but everywhere in this field. And but rather than thinking about what is shown, like when you have a new digital tool, you can see it. Everyone is like, "Wow, this is wonderful!" Yeah. But is it really improving the quality of justice? I'm not sure. What could be the first step would be first to have judges, prosecutors who are aware of their digital environment, because it comes with many opportunities and we want to take these opportunities, but we also want to be aware that it comes with threats. So for example, I think a quick win would be to have judges who know that they should be careful while using AI tools, because you are responsible with personal data you are dealing with, you know. So you are, again, the ultimate guarantor of the rule of law. You are protecting the human rights. So you must be aware that you cannot put, maybe because you want to be more efficient, you know, you cannot put in an AI tool or in ChatGPT something to wrap up the file. So it comes with that. It comes with a dedicated, a specific training for judges, because we are not normal companies. We are dealing with personal lives, so it has to be really accurate. And here I would like to come on what the judicial training is, because you know, sometimes today, because it's easy to organize a webinar, we think you put someone in front of the camera, he makes lectures, and then, okay, you have your training. It's not what we do. The judicial training has to be very practical, hands-on, has to be really specific to the judge's need, tailor-made, and it goes also with peer exchanges. So they need to enrich their knowledge and know-how, but they do it also horizontally, because there is no, like, you have the answers, but every situation has to be taken carefully, thought through by any judge. So we have a competence in judicial training, in evaluation of the impact of what we do, and this is indeed a very special field.
Thank you. Ingrid, thanks very much. And nothing compares with practical lived experience, and thank you for those examples. I will turn now to Srdjan. Serbia has been mentioned already, and congratulations. I'm not sure if you had anything to do with it, but for winning Ingrid's competition and being able to host the next one. But you know, you've worked, as I said, on EU accession in government, and of course now you look at it from the standpoint of the sort of the academic think tank community. Not just Serbia's experience, but you know, how far do you think the region has come, and you know, do you identify with some of the issues that Ingrid raised from her engagement with the region? So, over to you, sir.
Thank you very much. It's a tough act to follow. I utterly enjoy your presentation because it comes from your experience, and this is what people can feel and to recognize as important. But I would start first by obviously saying a big thanks to Friends of Europe for organizing this event and allowing me to be, I think, the only representative of civil society at today's conference. And I'm today representing a group of 6 think tank organizations from the region as a good example of a good regional cooperation, and that when there is a will, the Western Balkans 6 can do it, regardless of our differences. And we are different. I'm always utterly flabbergasted by the fact that people speak about the Western Balkans as a unity. It's not. It's a bit of intellectually lazy perception of the region. And let me paraphrase the famous start of Tolstoy's Anna Karenina, you know, when he says all happy candidates look alike, but those who are unhappy candidates, they have reasons why they're unhappy. And I think it applies to the Western Balkan countries. We have 2 very happy candidates. We have Montenegro and Albania, who are pushing forward. I would dare to say that Moldova, although not part of the Western Balkan, is catching up, and this is very good. Because for the enlargement to be efficient and to be recognized and to have a certain degree of legitimacy, it needs to have a critical mass. So it's better when there is more countries preparing. And by the way, during the lunch, I had a pleasure, as always, when speaking with Professor Reinhard Priebe. I said, maybe this group is going to change, will be joined by some additional countries like Iceland. You know, the government there is calling for a referendum during 2026 to restart the EU accession process. I think it will be marvelous for this critical mass of countries to be even bigger and more consistent, because the accession will require ratification in member states. And obviously, as the more candidates join, the case for the enlargement will be stronger. But going back to the topic, I'm sorry, Jeremy, for this extended introduction.
No, we love geopolitical introductions and scene setters, so
Yeah, but-
please not, because it's important to understand, where the driving forces come from.
It is always about a context, and this is why we need to address the context in which judicial reform, which is a topic of today's panel, is set to be held. And this is the question of actually functional democracy. There are two concepts of how justice is delivered: by the rule of law, which considers all citizens equal, all players at the market equal, or undemocratic rules where might is right. And when there is an arbitrary force that decides who is more equal than the other actors. And this is why it is important to put the judicial reform in the context of vitality of democracies in the region. Unfortunately, the recently published enlargement package shows a very sketchy picture. It shows that in some of the countries of the region, division of power and mutual checks and balances still not developed to the level of sufficiency. It shows that there is a still overwhelming influence of politics and executive power over judiciary, which obviously fails the standards that Ingrid was describing. Our legislation, our parliaments are failing to produce the parliamentary oversight very often over the judiciary, but also over other regulatory bodies. And in that sense, this is an issue. One step further, we are lacking a public oversight of what's going on. And these are the issues very closely connected to the fundamental freedoms of expression. You cannot have democracy, you cannot have a properly functioning political system without the ability to speak freely and to be critical towards your government and to speak openly about it. You need to have a public platform because, as Washington Post says, democracy dies in the dark. So you need to have a free media where judges can go and share their problems and share their views on different points. But you also need to have this elusive fourth branch of government, that this is a civil society, where civil society organizations, these stakeholders, which are part of the policy-making cycles, need to have an access and need to be included in these reforms. Two another very big challenges. One is mentioned by Ingrid. The regional cooperation is thriving among the organized crime, unfortunately. Corruption is a high enemy of what we are talking about. And obviously, even the two happiest candidates need to address these issues now in the final stages of their EU accession, inshallah, in a much better, more substantial way to prove the track record that they able actually to implement what they negotiated throughout this process. And the third point with concerning challenges is the culture of impunity that undermines the trust that Ingrid was mentioning, and that citizens go to the judges with the expectations to be treated equally and to be able to protect their rights. If there is no that trust, if there is a culture of impunity rather present, it is very, very difficult that our reforms can survive. And the second point I would like to raise is how can EU and Western Balkans collaborate more effectively to move forward? And there are some very positive examples. I would say that inclusion of 4 candidate countries in the rule of law mechanism, EU rule of law mechanism, is an excellent example of the gradual integration of the candidates into the broader European framework. What actually gradual integration means? It means that the candidates can feel some early benefits of being together engaged in the EU reforms. It serves to spread knowledge, to create networks that you mentioned, but it also serves to socialize judges, for example, in this case, of the candidates' countries with judges from France, from the Netherlands, from Austria or Germany or whenever. So the gradual integration works. Another good example is a growth plan that was mentioned in the previous panel. It is important to notice that all growth reform agendas which are created by the candidates, by the Western Balkans 6, sustain the fundamentals and the rule of law pillar within the reform agenda. And this is an area which belongs to the fundamentals and is going to be crucial when approving the financial resources being granted through the growth plan. I must say this is still an early stage. Some analysis which was prepared by our colleagues from Skopje, from North Macedonia, European Policy Institute, who is in charge of following the growth plan on behalf of the Think for Europe network, are showing that there are some delays. There is a problem of poor data access, especially for civil society activists, and that there is unfortunately weak inclusion component of the relevant stakeholders into the monitoring. And finally, and I will finish with this, it's not all about the geopolitics. It's not all even about the economics. It's about the values as well. And this is why one part of the gradual integration is so dear to my heart and important. And this is inclusion of the Western Balkan countries in the European Democracy Shield and invitation to be a part of the EU civil society strategy. These are the numerous areas of the context that we are speaking about, which are crucial for all of us to be successful when dealing with the reform of judiciary and introduction of the properly functioning rule of law principle.
Sergio, thank you very much, but don't put the microphone down immediately. Just a quick follow-up. I think at meetings like this, we want to look a little bit beyond the news headlines, the story of the day, the perception of the day, and get at the underlying facts, the bit of the iceberg which is under the water. Over the Commission in its enlargement package did say some sharp things about the rule of law in Serbia, and of course, looking at the TV, we've seen, of course, all of the political turbulence affecting the country over the last year or so since the Novi Sad disaster. On the other hand, people do say that, despite this turbulence, reforms keep going. Look at the broader context, and it's not stopped simply because there seems to be a political turbulence. What's your assessment of that? Is